Okay. Deposit and trust account of trust escrow funds. Um, the obligation of the broker to remit monies, valuable documents, and other property coming into his or her possession within the meaning of subparagraph 6, 858, 312, shall be construed to include but not limited to the following. Shall deposit all checks and monies of whatever kind and nature belonging to others in a separate account. Okay? Duh, we knew that. Broker is required to be a signer on any brokerage account where such funds are held. Any brokerage account where such funds are held must be in the name of the broker as it appears on the license or trade name as registered with the commission. All escrow funds must be deposited before the end of the third banking day. That is a test question, I know that. All escrow funds must be deposited before the end of the third banking day following acceptance of an offer. The broker shall ensure such funds are maintained in said account until the transaction involved is consummated and terminated and proper accounting made. The broker shall at times maintain all accurate and detailed record thereof. Okay? Funds referred to in this subsection shall include but are not limited to earnest money deposits, money received upon final settlements, rents, security deposits, money advanced by buyer or seller, or the payment of expenses in connection with closing of real estate transaction, and money advanced by his or her principal or others for expenditures on behalf of the subject principal. Okay, commingling, we know about this. Commingling is definitely prohibited. A broker may not keep any personal funds in the trust account except amounts sufficient to ensure the integrity of the account and cover any charges made by the financial institution for servicing the trust or escrow account. This fucking, it hurts my ears. I don't like this headset. Interest-bearing account. A broker shall not be prohibited from placing escrow monies in an interest-bearing account. However, he or she must disclose in writing to all parties that the account bears interest and identify the party receiving the interest. Okay? Trust account, not mandatory unless funds or items are held. A broker shall not be required to maintain a trust or escrow account unless monies or other depositable items belonging to others are accepted by the broker and require the broker to place the monies or items in the broker's trust account. Trust accounts must be registered with the commission. A broker shall be required to notify the commission in writing of all trust or escrow accounts, security deposits, rental management operating accounts, and interest-bearing accounts in which trust funds are held. Settlement statement to be furnished. A broker shall ensure that a signed settlement statement is furnished in each real estate transaction. Documents, items, or monies furnished to all parties. A broker shall ensure the timely delivery or return of all documents, items, or monies to a party to a transaction wherein the broker or the broker's associate have provided services. Inform all parties pertaining to escrow being held. A broker shall ensure that all parties of each transaction are informed of the details relating to the escrow, including a statement as to the nature of the non-depositable item, the value of the item, and whose custody the item is being placed. And then it goes on to talk about record retention one more time. A broker shall maintain all records and files for a minimum of 5 years. Remember that, because that's one test question, and the one before it was one test question, okay? Okay, and then the trust account records shall be maintained by the broker in their original format for a minimum of 2 years. Duty to account as pertains to associate, the obligation of an associate to remit monies, valuable documents, and other property coming into his or her possession within the meaning of the subsection 858.312 shall be construed but are not limited to the following. Shall turn over all documents, files, and monies deposited, payments made, or things of value received by the associate to his or her broker promptly, and shall deliver a copy of all instruments to any party or parties executing the same when such has been prepared by the associate, shall not be authorized to open or maintain a trust account, or be a signer on a trust account or escrow account, wherein the associate is providing license activities as defined in the code. An associate may open or maintain a trust or escrow account or be a signer on a trust or escrow account when the associate is performing activities as outlined. Okay? Disclosure of beneficial interests or referrals. No licensee shall, without disclosing such fact in writing to all parties on both sides of the transaction, okay, and then we're back to the Brokerage Relationship Act, the first part. In 605-1015-2, Brokerage Relationship Act, to become effective November 1st, 2013. Okay? A new law, Title 59 OS, Section 858351 of the License Code becomes effective on November 1st, 2013, which law shall be referred to as the Broker Relationship Act. Okay? So that law that we read in the first video is now going to be referred to as the Brokerage Relationship Act. So it's under a new name, okay? It shall be referred to the Brokerage Relationship Act. Brokerage Service Agreement defined. The term brokerage service agreement shall mean an oral or written agreement to provide brokerage services entered into by a real estate broker and a person who is a party to a real estate transaction, and shall include a listing agreements, buyer broker agreements, and property management agreements. Okay, providing services to one or more party to a transaction. When a firm provides brokerage services to more than one party to a transaction, the broker shall provide written notice to those parties that the broker is providing services to more than one party. Okay, requirements for furnishing psychological factors. That is all in your midterm right there. Okay. Residential Property Disclosure Act. This also has a little note that says test question. Development and amendment forms. In accordance with the Oklahoma statutes, Title 16, Section 833, the Commission shall develop and amend by rule the forms of the Residential Property Disclosure Statement and Residential Property Condition Disclaimer Statement. Effective July 11th, 2018, that seems important, July 11th, 2018, the disclosure statement is amended and all disclosure forms executed prior to July 11, 2018 will remain in force and valid until the expiration of the 180 days from the date noted therein. Commissions and disputes. The Commission shall not establish the rate of commissions to be charged for real estate services and shall have no interest therein. Okay, complaint procedures. Complaint may be filed by public or Commission's own motion. A complaint alleging misconduct on the part of a licensee or any person unlicensed pursuant to the code who violates provisions of the code may be filed by any person in writing on a form for such supplied by the commission, or may be ordered by the commission on its own motion. The commission will accept a complaint alleging misconduct on a form not supplied by the commission if such form is notarized by the notary public. So they will accept something else not on the official form as long as it's notarized. Complaint notification, licensee response. When a complaint has been filed, the licensee or the licensed persons pursuant to the code shall immediately be notified and shall be required to file an adequate response within 15 days of notice. So if you get a complaint, hopefully you won't, you have 15 days. You'll be notified immediately and you'll have 15 days to provide an adequate response. Okay, complaint hearings, notice, and procedures. Okay, that says not important, so we don't need to do that. Prohibited dealings. Okay, untrustworthy, improper, fraudulent, or dishonest dealing shall include the making of brokerage service contract without a date of termination. That seems like a test question. You can't make a brokerage service contract without a date of termination. Okay? Purchasing a property by a licensee for himself or herself for another entity in which the licensee has an interest, as defined in the 605-10-15-1. Such property is listed with the broker or the broker's firm without first making full disclosure thereof and obtaining the approval of the owner, or the failure by the licensee to exert the licensee's best effort in order to later purchase or acquire the property for themselves or another entity in which they have an interest, as defined in 605-10-15-1. Okay? And here we go, continuing on prohibited dealings, meaning you can't do this type of shit. Okay? Repeated misrepresentations, even though not fraudulent, which occur as a result of the failure by the licensee to inform himself or herself of pertinent facts concerning property as to which he or she is performing services. Procuring the signature and dates of such signatures to a purchase offer or contract, or to any lease or lease proposal which has no definite maximum purchase price or lease rental, or no method of payment, termination date, possession date, or property description. The payment of any fees or amounts due the commission with a check that is dishonored upon presentation to the bank on which the check is drawn. So no bounce checks. Okay. Lending a broker's license to an associate, permitting an associate to operate as a broker, or failure of a broker to properly supervise the activities of an associate. Failure to make known in writing any purchaser, any interest the licensee has in the property they are selling. Failure of the licensee to inform the buyer and seller in writing at the time the offer is presented that the buyer and seller will be expected to pay certain closing costs, brokerage service costs, and approximate amount of said cost. Failure to respond to a complaint in writing, or to disclose any information within the licensee's knowledge that is real estate related. Failure to reduce an offer to writing when a proposed purchaser requests such offer to be submitted. Failure to submit a bona fide offers to an owner when such offers are received prior to the seller accepting an offer in writing. Any conduct in real estate transaction which demonstrates bad faith or incompetency. Failure to act in marketing the licensee's own property. An associate who does not possess the license of a broker or branch office broker as defined in the rules. Discouraging a party from obtaining an inspection on a property. Allowing access to or control of real property without the owner's authorization, knowingly providing false or misleading information to the commission, interfering with an investigation by means of persuading, intimidating, or threatening any party or witnesses, or tampering with or withholding evidence relating to the investigation. Yeah, you can't do that. Can't be like, hey, motherfucker, do this, or I'm gonna beat your ass. Okay? Knowingly cooperating with an unlicensed person or entity to perform licensed real estate activities, failing to disclose any known immediate family relationship to a party to the transaction for which the broker is providing brokerage services. An associate shall not perform licensed activities outside their broker supervision, failing to maintain documents relating to a trust account or a real estate transaction. Okay, it also has a note right here that says test questions. Okay, so substantial misrepresentation. So that's what we're on, 858-12. But it's 605-1017-5, but it's referencing the substantial misrepresentation within the meaning of 858-12. Okay, the recommendation or use by a licensee of a fictitious or false instrument for the purpose of inducing a lender or government agency to loan or insure any sum of money. Failure to disclose to a buyer the condition of a parcel of real estate of which broker or associate has knowledge. The use by a real estate broker of the name or trade name of a licensee whose license has been revoked or currently on suspension, representing to any lender, guaranteeing agency, or any other interested party, either verbally or through the preparation of false documents, an amount in excess of the true and actual sales price. So that is telling a lender that you need more money than what you really need when the sales price is lower than what you're asking for. You can't do that. Okay? I think we already went through the requirements for a suspended revoked license. A suspended revoked license shall not engage in any activity which requires a real estate license. A suspended revoked licensee must return their license certificate and pocket identification card to the commission office on or before the date the suspension revocation. When the suspension revocation period becomes effective, the licensee shall comply with all these requirements. When a broker's license is suspended, associates under the suspended revoked broker supervision will automatically be placed on inactive. So if you are working for a broker and their license gets suspended, your shit is going to become inactive, which sucks, okay? Unless the licensee requests to be transferred to another broker. So you can be transferred to another broker if the broker gets suspended, but hopefully you'll be with a good broker. Okay, if a managing corporate broker of a corporation is suspended, revoked for an act which was on behalf of the corporation, all licensees associated with the corporation will automatically be placed on inactive. And then it goes on for partnerships. It's the same concept. If you're with a partnership, you'll be placed on inactive. If a managing broker, member of an association is suspended or revoked, all licensees will be revoked for that. A suspended revoked licensee shall only receive compensation during the suspension revocation period for acts which were performed during the period in which the licensee was actively licensed. So the only thing you're going to get paid for is for the acts that were performed while you had an active license. Of course, because you can't perform any acts while you're inactive because that's a violation of the rules. So, of course, you're not going to get paid for shit because you're not going to be doing shit, right? Listings must be canceled by a suspended revoked broker between the time the order of suspension revocation is received and the effective date of suspension revocation. A suspended revoked broker shall not assign listings to another broker without the written consent of the owner of the listed property. The suspended revoked broker shall not advertise real estate in any manner and must remove and discontinue all advertising. The telephone in which the suspended broker's office shall not be answered in any manner to indicate that the suspended broker is currently active in real estate, so you can't even answer the phone. All pending contracts, items, or money placed with the suspended broker must be transferred to another responsible broker as approved by the commission and in compliance with Section 605, 1013-1. A suspended revoked licensee shall be required to comply with Section 605, 1013-1 and provide the required information to the commission prior to the effective date of suspension revocation. A representative of the commission shall visit the office of the suspended revoked broker prior to the effective date of the suspension to ensure compliance with the requirements. So a member of the commission is going to be checking up on that broker, making sure he ain't pulling some shade, trying to do something. Okay, we got that done. Tomorrow we are going to record these tests, and maybe that'll help, but I don't think any of those test questions are on there. So just try to focus and try to pay attention as best you can. Okay?